Hey, everybody. Thank you for coming in. We are just chilling and we're going to talk about the Calais decision we had. It took me a few days to kind of want to do this live because I think this decision is incredibly atrocious. But we're going to talk about the decision tonight, dealing with the Voting Rights Act. And I think something to keep in mind always when you read these rulings, this is not a pass for anybody making the ruling. This is not a this is okay. But in law, the crappy thing is that something can be amoral and unethical and still be okay in the eyes of the law. And I think we're going to see a lot of this as we kind of move through this. We may replay the oral arguments because you genuinely want to know how they arrived at these decisions. So I'm going to start with reading the summary and then we will go from there. So just give me a second. So Louisiana versus Callais et al. Appeal from the United States District Court for the Western District of Louisiana. These cases concern whether Louisiana's new congressional map is an unconstitutional racial gerrymander. In 2022, after the state redrew its congressional districts, a federal judge in Robinson v. Ardoin held that the 2022 map likely violated Section 2 of the VRA of 1965 because it did not include an additional majority black district. But when the state drew a new map, SB 8, that contained such a district, the new map was challenged as a racial gerrymander. It's fucking amazing. A three-court judge in Callais versus Landry held that SB 8 violated the Equal Protection Clause of the 14th Amendment, and the state appealed to this court. The parties originally briefed and argued that this suit last term, and their arguments at that time highlighted problems in the existing body of the Section 2 case law. One problem resulted from the rule that in racial gerrymandering cases, unlike other cases involving claims of racial discrimination, strict scrutiny is triggered only if the race predominated in the state's decision-making process. Another problem stemmed from the long unresolved question whether compliance with the VRA provides a compelling reason that may justify the intentional use of race in drawing legislative districts. For over 30 years, the court has simply assumed, for the sake of argument, that the answer is yes. These and other problems convince the court that the time has come to resolve whether compliance with the Voting Rights Act can indeed provide a compelling reason for race-based redistricting. Oh, did I turn it back on? Sorry, guys. Held. Because the Voting Rights Act did not require Louisiana to create an additional majority-minority district, no compelling interest justified the state's use of race in creating SB 8, and that map is an unconstitutional racial gerrymander. A, the Constitution almost never permits a state to discriminate on the basis of race, and such discrimination triggers strict scrutiny. The court's precedents have identified only two compelling interests that can satisfy strict scrutiny: avoiding imminent and serious risks to human safety in prisons. And I'm sorry, guys, if you are commenting, I promise I'm going to come and look through the comments, but I'm reading, so it's hard for me to see all the comments. Court's precedent, I've identified only two compelling interests that can satisfy strict scrutiny and remediating specific identified instances of past discrimination that violated the Constitution or statute. And that is Students for Fair Admission versus Harvard, because of course. The question presented is whether compliance with Section 2 of the Voting Rights Act should be added to this very short list of compelling interests. The court now holds that compliance with Section 2 as properly construed, can provide such an interest. A proper interpretation of Section 2 requires examining the statutory text to understand what it demands with respect to drawing legislative districts. I swear to God, this is ridiculous. Oh, dang it. What did I do? Maybe I hit escape? Hold on. I don't know how to reduce this now because, of course, I'm a dummy. Okay. Anyway, sorry, guys. Let's see. Legislative districts. Under Section 2A, the court takes as given that a legislative districting map may constitute a standard practice procedure that may violate Section 2 if it results in a denial or abridgment of the right to vote on account of race or color. Section 2B establishes that a violation occurs when the political processes are not equally open to participation by members of a racial group, and that they have less opportunity than other members of the electorate to elect representatives of their choice. The key concept is less opportunity with other members of the electorate, which sets a baseline which to assess the opportunity of minority voters. That baseline, the opportunity that any given group of voters has to elect their candidate of choice, depends on the voting preferences of other voters in the district. For example, in a district where most of the voters prefer Democratic candidates, a Republican voter in that district will have a low chance of securing blah, blah, blah. The roster of voters who end up voting in a district depends in turn on the districting criteria the state uses to draw the map. Thus, opportunity of these members of the electorate to contribute. This is absolute dog shit already. I'm sorry. I said what I said. It's fucking words. Oh, Alito wrote it, so now I know what I'm dealing with. Cool beans. Anyway, so what I want to do is let's go ahead and replay arguments. It's going to give us a lot more here. See Louisiana v. Callais.
We will hear argument first this morning in Case 24-109, Louisiana versus Callais, and the consolidated case. Ms. Nelson.
Thank you, Mr. Chief Justice, and may it please the Court. A mere 2 years ago, in Allen versus Milligan, a case nearly identical to Robinson, this Court noted that under certain circumstances, it has authorized race-based districting to remedy state districting maps that violate Section 2. Louisiana affirmed findings that, six appellate judges affirmed findings that Louisiana, in the face of extreme racially polarized voting, packed and cracked Black voters, and it rejected 7 non-dilutive maps in favor of one that would give its 58% declining white electorate entrenched control over 83% of the congressional districts. Louisiana's creation of a district to remedy that discrimination and to ensure that Black Louisianans have an equal opportunity to participate in the process is constitutional. Precedent from Brooks to Milligan, from Ex parte Virginia to SFFA confirm that. And 3 facts guard against indefinite use of race. First, not all Section 2 remedies center race. Second, when racialized politics and residential segregation wane, so will the ability to satisfy jingles. Third, almost every redistricting map is replaced decennially. My opponent's late-breaking and recordless facial and as-applied challenges seek a staggering reversal of precedent that would throw maps across the country into chaos. If SB 8 is unsatisfactory, the proper recourse is to remand and adopt one of the many alternative maps that address the Section 2 violation and satisfy the Constitution. As this Court noted in Milligan, Congress is undoubtedly aware of Section 2 precedent and can change it if it likes. But unless and until it does, statutory stare decisis counsels staying the course. I welcome your questions.
Counsel, what was the finding or the
Thomas.
holding in Robinson, and what role does it play in the SB 8 map creation?
The finding in Robinson was that there was a likelihood of succeeding in a Section 2 claim proving that the state of Louisiana violated Section 2 by packing and cracking black voters. So there was a Section 2 liability finding under a preliminary injunction.
Thomas, do you have a question?
No.
Cool story, bro. Did you come up here for anything?
Yeah, I like the Callais decision.
Super. Yeah, we're not debating that. We're actually listening to the argument. So
Why, though? Do you not know the arguments? Are you dumb?
that's really special of you. No,
Nah,
I'm
you
not. Any hoodle.
And there was an ordering of a new map to be drawn.
What is the status of that case now?
Robinson is concluded, and there's now, as we know, the challenge in Callais that suggests that their map that was created out of Robinson, SB 8, is a racial gerrymander, and that's why we're here today.
So SB 8 was the remedy for the Robinson case. I thought that was a preliminary injunction.
Yes, there was a preliminary injunction indicating that we were likely to succeed if we continued to pursue a claim. This is after a 5-day hearing with 21 witnesses and a robust record. So the court found, based on that evidence, that we were likely to succeed on liability and ultimately instructed the state of Louisiana to draw a correct and constitutional map.
But there was never a full merits determination.
That's correct.
SB 8 was entirely separate, though, from that litigation.
SB 8 came after the litigation. It was in response to the court's order to create an opportunity district and a second map that would cure the Section 2 violation.
But did the court order this particular map?
No, the court gave the state of Louisiana an opportunity, as this court has suggested it do. It gave it broad discretion, gave it wide latitude to create a map that it felt was satisfactory, and ultimately that is the map that was in effect and elected a congressional delegation in 2022.
Counsel, you began with Allen against Milligan. That case, of course, took the existing precedent as a given
Roberts.
And considered Alabama's application of its approach to the evidence and all that under that precedent. Is that your understanding as well?
That's correct. In fact, the case was stayed because this court held that case in abeyance until it decided Milligan, because it understood Milligan to be important.
Sorry, I can't work my computer while I'm doing this. So something to note here, what they're discussing is sort of the beginning, where this case began. They had a map drawn, and then they filed, and it was saying that the court said it was likely that they would succeed on the merits, that there was not a majority black district based on this. So they gave the state the opportunity to withdraw SB 8, right? Like this new map that was created to sort of limit the fact that like black people did not have a majority district in a majority black area. And then some people got big sad and said that, oh no, because they have a majority black district, this is racist. So this is what's happening with this entire case, very similar to the Harvard case. So we'll get back into it.
Important to understanding the case in Robinson.
But it was a case in which we were considering Alabama's particular challenge based on its what turned out to be an improper evidentiary showing.
I'm sorry.
In other words, we were looking at Alabama's suggestion that how to apply its body of evidence or which evidentiary considerations we should take into account under the existing precedent.
That's correct.
Thank you.
But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant, or the fact that we held or what we held in that case is relevant to what we're doing here today?
Allen versus Milligan is a nearly identical case. There was a similar challenge where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt.
This is like a
and
landmark
ultimately
case.
this court
If
found that was a
nobody's
clear
aware, I'm gonna
violation
call it,
of
it's a
Section 2.
landmark case.
Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a remedial form when necessary. So those questions have been asked and answered by this court in Allen versus Milligan, and some parties here recognize that those are closed questions.
Can I ask you a question about what Milligan means? In Milligan, the court said that the first Gingles precondition is that, quote, the minority group must be sufficiently large to constitute a majority in a reasonably configured district. And then it went on to say that a district will be considered reasonably configured if it comports with traditional districting criteria. Would you agree that incumbent protection is one of those?
Incumbent protection has been considered a traditional districting criteria. However, we know that protecting an incumbent, like core retention, can continue to perpetuate discrimination. And it does not trump the anti-discrimination principle.
All right. If incumbent protection is a permissible districting criteria, then under Rucho, isn't seeking partisan advantage also an objective that a legislature may legitimately seek?
Not if it comes at the cost of the equal protection principle and the 15th Amendment's prohibition on race discrimination in voting. It is not.
Well, if the objective is simply to maximize the number of
gerrymandering
representatives of a particular party, that's seeking a partisan advantage. It is not seeking a racial advantage. Isn't that right?
Well, if race is used as a means to seek the partisan advantage, then that is unconstitutional.
Oh, sure.
There's no
if race is used as a proxy for partisan affiliation. Let me ask you a related question about block voting, which is the second figures in the second and third Gingles precondition. If registered Democrats overwhelmingly vote for Democratic candidates, regardless of the candidate's race, is that block voting?
If you're looking at it simply from a party perspective, no, we don't judge block voting based on party. We judge it based on race. Racially polarized voting is measuring racial performance and voting behavior.
And likewise, if registered Republicans overwhelmingly vote for Republican candidates, that's not block voting.
That's not how we measure voting. We measure voting based on race for purposes of Section 2 because the Constitution forbids race discrimination in voting, not party discrimination.
All right. So if it happens to be that people of one race or another race overwhelmingly
Sorry, y'all. I'm still trying to adjust because I can't get that window off maximize. Okay, so here's the issue, right? I hear what they're saying, but like, let's be so real that like you can use race to create a district, but how likely are you to tell somebody that you're cracking and packing Black voters or other people of color in order to weaken their vote? You're not, right? And because for at least the majority of the Black population, they do vote overwhelmingly Democrat. This gets into a very tricky area, right? Like, because I think I can make a strong argument that also allowing race to not be a factor can also lead to discrimination. And that's what I hate about this whole argument.
We prefer one of the political parties. Does that transform the situation into racial voting, or is it still just partisan voting?
No, you look at how different races of voters vote and whether they vote in a way that is polarized. And the Jingles test requires us to look not only at that, but a number of other features as part of the totality of the circumstances test that suggest that race is playing a role to contaminate the electoral process and submerge minority votes in a way that violates the Constitution. So party cannot explain away a racially polarized circumstance unless we look at the totality of the circumstances. And I will say, in Robinson, for example, the court entertained testimony along those lines, as it did in Milligan, and found that it wasn't credible, that the extreme racially polarized voting that we have in the state of Louisiana cannot be explained away by party. We're talking about racially polarized voting that is above 84%, which is more than what this court found in Thornburg versus Jingles in 1986, when the numbers were 70%.
That could be easily analyzed by statistics to see whether whether white Democrats vote for Black Democratic candidates at a lower rate than they do for white Democratic candidates, whether white Republicans vote for Black Republican candidates at a lower rate than they do for white candidates. It's easy to
see why I bully
race
Alito
from that to see whether there really is racially polarized voting as opposed to partisan polarized voting.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case, and it was clear that regardless of party, white Democrats were not voting for Black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how Black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Can you comment on the Solicitor General's suggestion at page 25 of its
Sounds like
brief
Kavanaugh.
that the court should hold that plaintiff's illustrative district cannot disregard the state's political objectives, and goes on to say Section 2 plaintiffs cannot claim a lack of equal openness where politics rather than race is the likely reason for the state's refusal to create a majority-minority district?
Yes, that suggestion would swallow Section 2 whole. As I said, party cannot trump the responsibility of states to ensure that all voters have an equally open electoral process. The fact that Black voters may correlate with voting Democrat or white voters may correlate with voting Republican does not deny the fact that there is racially polarized voting, and the totality of the circumstances, including the inability to elect Black candidates in Louisiana on a statewide basis for a number of offices. There's never been a Black person in Louisiana elected statewide is additional indicia.
Oh, I'm sorry. It said you couldn't hear me. You're welcome, Uplaw. I can stop this to actually talk about the decision. We're kind of listening to oral arguments and kind of going through it a little bit more again.
That race is playing an outsized role in the electoral process in Louisiana. And so the idea that you have to show that a party is the reason for the racially polarized voting would eclipse the entire Section 2 analysis, which is focused on ferreting out and ending race discrimination in the political process.
You said several times that it's playing an outsized role. What's the proper size? In other words, is that wiggle room we're talking about, or a significant percentage? What is meant by outsized?
So this court has held for a long time, beginning in Shaw and in many cases since, that there's always an awareness of race. There are always racial considerations and even race consciousness in the districting process. What becomes potentially unlawful is when race is the motivating factor. That's what Miller versus Johnson taught us. That's what Milligan reaffirmed, that the line between the appropriate use of race.
Okay, I want to go back to what I said at the beginning of this when some of y'all weren't here. As unfortunate as this sounds, because we're kind of working through this reasoning here, this is not giving a pass to what happened. I'm simply telling you that in the law, sometimes things can be unethical AF and still be legal. Sometimes things can be morally bankrupt AF and still be legal. So like when we're looking through these decisions, we're trying to see it from a neutral perspective. As much as this personally horrifies me, on a legal side, I'm going to try to look at it and have like an even ground. I didn't do that as much with my last live when we reviewed this because I couldn't step out of that what am I reading shit. But yeah, we're going to get back into this and talk about it more.
And the use of race that will get us into the strict scrutiny territory is the dividing line between motivation and general awareness. And what I'm explaining here is that when voters are blocked by a white bloc vote that is so substantial that it usually overrides the politically cohesive vote of black voters, then we have at least a prima facie case of vote dilution. And then the court is asked to consider the totality of the circumstances. If I may address the durational limit question, which came up, I'd like to talk about the fact that Section 2 is self-limiting. I know that there is a general concern about the indefinite use of race, and there are several reasons why that concern should be allayed. First and foremost, there is no precedent to suggest that a statute must dissolve on its own simply because it may require a race remedy. And as I've mentioned, race is not required by Section 2, but it can be used if that is necessary to address the Section 2 violation. In addition, the non-discrimination element of the 15th Amendment is a permanent right, and so should be the protection that Section 2 affords. And finally, this is a significant concern where Congress was very clear that it did not want to include a durational limit. Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this Court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what
That's not
exactly
what
do you think
Congress said,
the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So, for example, this case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act. And also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. That particular aspect, I'm guessing, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require.
I guess what I'm saying is that this is like sort of this age-old, like boxed-in argument of basically, can Black people be racist, and can and how does that, this feels like a super boxed-in argument of that. White people feel can white people experience an equal amount of discrimination or racism? And I'm not saying that's what this argument is. I'm saying that's what it feels like. This is from a personal perspective. I don't know if that's how it comes across legally, but certainly from a personal perspective.
A race-based remedy in all circumstances.
Is that because? Can I ask? I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
Just assuming that it
my
question is.
Sure. Assuming that it does, as you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting the 1982 amendments.
I guess I wonder if it would be helpful, at least as I'm thinking about it, because I think this is a very important question. To understand, I think, that you're saying that Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist, and those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to figure out what that remedy will be, and maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
And so that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right. And its usage becomes less and less as we see racially polarized voting and residential segregation decreasing. The Katz amicus brief in this case shows that in the past decade, Section 2 cases have decreased by 50%.
Because the plaintiffs can't make the showing. I mean, it's a pretty significant showing to establish that unequal opportunity of electoral processes is happening in a situation.
That's correct. Jingles is an exacting test. It is data obsessive. It brings in experts and many other forms of evidence to establish a racial violation. There are many cases where the plaintiffs fail in bringing the Jingles 1 precondition or Jingles 2 or Jingles 3 before they even get to the totality of the circumstances.
So if we're talking about a time limit, you would say maybe it's with respect to the remedy that is used to respond to the problem that we've identified under Section 2. But the Section 2 tape measure itself doesn't need a life cycle. It's just
no.
Yeah.
That's correct. I mean, the 15th Amendment is permanently enshrined in our Constitution, and Section 2 is there to effectuate that prohibition of race discrimination on voting and does not require a time limit.
Thank you.
With the time I have remaining, I'd like to mention that there are many proposals on the table that have been presented by my colleagues on the other side, and a number of them resurrect the intent standard that this court was very clear about, and Congress was extraordinarily clear about, knowing that results is key to ensuring that we do not continue to have rampant racial discrimination in voting. And the absence of it, or the declining ability to show a Section 2 case, is because of the success of Section 2 over the past 4 decades. And we would be reckless if we determine that Section 2 somehow is no longer needed simply because it has been so successful in rooting out racial discrimination in voting. There's also
So as to, is Jingles now moot? Let's go find an answer to that. Now moot. Oh, somebody's requesting. Hold up. I can't see. Hold on.
Yeah. So yeah, I asked if Jingles was now moot, but in addition to that, I see Law's response in the comment section here, as long as no one says the quiet part out loud. So in essence, have to prove intent, and the only way to prove intent is if they explicitly say that they did this, based on racial lines. So my next question is, if that is explicitly written in law, is the Supreme Court now writing law? Or is the Supreme Court now like making amendments, to law, or like revoking amendments to law? Like I don't understand.
I mean, that's the question, right? Like I think that they are more concentrated on limiting existing legislation from the bench than making legislation. But certainly it could be different interpretations of legislation. I'll give you that.
I don't know. I think we need to start challenging some of these things on their merits to the Supreme Court. Have them revisit some of these things, because evidently precedence means nothing.
I mean, the thing about precedent is it's kind of, exists to be overruled. And look, man, like, I'm not saying it should be all the time. That's not the claim I'm making. I get mad about a lot of things, but then I'm like, I'm even more mad at those people I pay in Congress that aren't doing shit either. There's a lot of things we could have solved with codification and making sure legislation got put forward, and it just wasn't done the way it needed to be done. But regardless, I mean, they are interpreting from a very originalist, textualist perspective.
But are they though? Because like Louisiana, as a matter of fact, but the way that I understand it, excuse me, I have a popcorn kernel stuck in my throat. It's bothering me. The way that I understand it, the solicitor just put this case before the Supreme Court a couple years ago.
He probably, like, Jingles is not one I've seen in a hot minute. So yeah, but like, what are you getting at?
Or maybe it was, I'm not sure if it was Louisiana itself. I thought it was. And their opening like arguments, they addressed the solicitor from Louisiana saying, did we just,
oh yeah, no,
argue this whole thing?
Callais was a hot mess because the first argument, Louisiana was like arguing on the opposite side of it. They
exactly
did think it was, and it was, yeah, it's a crazy case and a crazy flip-flop. It was hilarious to watch them go from this to this.
I didn't hear the first oral arguments the first time around. This time around, I was thinking there is no way that these Supreme Court justices are going to somehow change their entire interpretation of this in this short of a time. And it's like they were all like members of the Supreme Court the first time around. I think maybe minus Jackson. I don't get it. I really don't get it. And I don't know if anybody can confirm this or not. Rumor mill, and I try to treat these things, with the utmost caution. But rumor mill was that Donald Trump sat down with the 6 Supreme Court justices a night or two before this decision came out at dinner with King Charles. And the other 3 justices were not invited to that dinner. I don't know if that is accurate or not, but yeah.
I don't keep up with their social lives like that.
Unfortunately, I do. Or I keep up with the rumor mills.
I gotcha. I'm going to drop you back down. I just want to get through these arguments. All right. Have a good one. Bye.
Thank you.
All right.
As I mentioned at the outset, a very easy and elegant solution to this case. If SB 8 is not satisfactory, if the court believes, as the Callais panel did, that the state violated the Constitution in constructing SB 8, it should remand and use one of the many alternatives that are available that meet Section 2 and also comply with the Constitution. The liability finding in Robinson is undisturbed, and it must be remedied. If SB 8 is the inappropriate remedy, there are many other options for this court to pursue.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Yeah, let me pick up with where you left off, which related to the illustrative map in the Robinson case. And let me go back once again to what we said, what the court said in Milligan. The minority group, this is the first Gingell's precondition, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. Did the Robinson court apply that, or did the Robinson court simply say that the district in question in the illustrative map, the second majority minority district in the illustrative map, was compact? There's a big difference between the compactness of the minority group and the compactness of a district.
All of the 7 illustrative maps that we presented to the Robinson court were geographically compact. They met every traditional redistricting criteria. They even beat the state's maps on the very criteria that the state set forth that it was pursuing in the redistricting process.
Well, that wasn't my question. My question was, did the Robinson court find that the minority group was compact as opposed to the district being compact?
Yes,
it did. Very serious.
Yes, it did.
I believe it didn't, and nor did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious question about whether the black population within the district in question in the illustrative map was geographically compact. You have people from a rural area in the northwest part of the state, and you have people from an urban area many miles away.
Over here, just
combined
trying to
in a district, just for the purpose of getting over the 50% BVAP.
So, Justice Alito, you might be referring to SB 8 as opposed to the illustrative maps.
No, I'm referring to the illustrative map. although the same may be said about SB 8. But I'm referring to the illustrative map. Well, we don't need to argue about what was done in the case, but it's my firm recollection that what the district court did and what the Fifth Circuit did on appeal was not to apply the correct standard under Milligan. Thank you.
Justice Sotomayor?
Counsel, I would note that the state's maps joined people in districts from the far north all the way down and across the state.
That's correct.
The map that it put into effect. So the district wasn't compact, and neither were the interests necessarily compact, except that they were white voters, correct, and Republican.
Correct.
All right. Now, you have not addressed the issues of the unconstitutionality, which is what this re-argument was about. Justice Barrett mentioned congruence and proportionality. Others have suggested that our Harvard case is appropriate. One, Louisiana has said that the use of race in any way violates the Equal Protection Clause. Would you give us a couple of lines on why those, assuming, as the Chief did, that Mulligan and all of our cases and precedents support you?
Sure.
The others are now saying, your adversaries are saying, even if it does, we should still declare this unconstitutional. I don't know that you've addressed that.
Happy to. So SFFA is an entirely different case from the one before the court at the moment. SFFA made clear that it is still constitutional to use race to remedy specified discrimination, which is what we have in the state of Louisiana, what we showed before the Robinson court. So SFFA is, in fact, working more in our favor, we believe, than supporting our opponents. And there are many distinctions between this case and the SFFA case. For example, Section 2 is a decidedly remedial statute. SFFA involved the diversity rationale involving a admissions process with a university, not a statute that is derived from Congress's enforcement powers under the Reconstruction Amendments that deals with remedying discrimination. That is a very clear distinction. This court has been clear in Shaw, in SFFA, in Croson, in Fullalove, that you can use race in a limited way to remedy racial discrimination. The other factor that makes SFFA reconcilable with Milligan, which is controlling here, is that we know both decisions were issued within 3 weeks of one another. It is illogical to think that this court issued the SFFA decision and Milligan in the same term, in the same month even, and somehow those cases work at cross purposes with one another. So in our view, it is very clear that the case law before this court supports the use of race as needed once there has been a showing of specified discrimination. And the Section 2 test gives the court an inference of intentional discrimination to draw upon. Congress was very intentional in crafting the results test to balance the concerns of getting at all discrimination in our electoral processes, but also being mindful of a potential allegation of racism against states and other state actors. And so Section 2 requires neither a confession nor an accusation of racism. It looks strictly at results, which this court has upheld on numerous occasions, including most recently in Milligan, but before that in Lopez, in Bernie, in City of Rome, written by Justice Marshall for this court, made very clear that results is constitutional and that the use of race is permissible in remedying discrimination.
Justice Kagan?
Ms. Nelson, were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting?
My girl Kagan.
What could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, Every congressional member who is black was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in Louisiana has been elected through a VRA opportunity district, and nearly all legislative representatives have been elected on those same districts. So Louisiana alone is an example of how important it is to have Section 2 continue to be enforced to create these opportunities. We also know that after majority-minority districts have been created, they often no longer need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process, but it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
Thank you.
Justice Gorsuch?
When it gets to the remedy side, do you think a plaintiff in a Section 2 case has to come up with a map where race isn't the predominant factor in the map, or is it okay for a federal court to use a map on the remedial side that intentionally discriminates on the basis of race?
You do not have to use race to create the remedy in a map. And I think that
Well, I'm asking whether one can. Sometimes you don't have to.
Yes.
I understand that. I'm asking, is it acceptable under Section 2, as you understand it, given our precedents, for a court to intentionally discriminate in a remedial map on the basis of race?
Not in those words, not for a court to intentionally discriminate, but I think it depends. There may be a circumstance where the only possible remedy is the limited use of race. I will say that I think those circumstances are rare, and the permissibility of race is constrained by strict scrutiny. This court has a very clear precedent around ensuring that race does not motivate the line drawer in a way that requires a map to be drawn that isn't narrowly tailored, that uses race for race's sake. There are already constraints between Jingles and Shaw that keep the use of race within constitutional bounds.
I understand that, but one argument is often, well, once you've found a Section 2 violation, you've got a compelling interest to go ahead and discriminate on the basis of race in your remedial map. And I'm just wondering, do you endorse that view or do you reject that view?
I don't endorse the concept of discriminating on the basis of race if discrimination has been established under Section 2 and a state determines that it needs a very precise incision of race in order to remedy that Section 2 violation, then Section 2 and this court's precedent supports that.
So a federal district court can sometimes to remedy a Section 2 violation.
Well, not a federal district court. I'm sorry. I'm glad you emphasized that.
If I might just finish the question.
Yes.
Sometimes federal district courts order maps, and you're saying sometimes acceptable for a federal district court to order a map that intentionally discriminates on the basis of race.
I disagree with that formulation. So first and foremost, states and plaintiffs, as they put forth illustrative maps, cannot put forth maps that discriminate and that use race in an excessive fashion. The only actor that has broader leeway are states, because we give states breathing room. We give states wide latitude in order to balance their political interests and concerns.
So federal district courts can't discriminate on the basis of race in remedies, but states can?
Federal district courts can only order maps that are constitutional. And again, the constitutional boundaries are between Jingles and Shaw, which sometimes
permits
race.
States have more breathing room. So do they have the breathing room to intentionally discriminate on the basis of race?
They don't have breathing room to intentionally discriminate on the basis of race. They have breathing room to use race to remedy their own discrimination.
Okay, thank you.
Justice Kavanaugh?
I guess the hang-up there is the word discriminate, but your answer is that they can intentionally use race in those circumstances, correct?
We're now hung up on discrimination.
If needed. And there are often a wide range of possibilities and alternatives that don't require that.
And then I think you said so long as it's not excessive, and you mentioned strict scrutiny as well, correct?
Correct.
But part of strict scrutiny, again, is the temporal limit. That's been part of strict scrutiny for a long time. And I think your answers earlier to that, to me, and when you were talking with Justice Jackson, were, well, Congress, defer to Congress. But when we're applying the Equal Protection Clause, or as Justice Barrett said, the 15th Amendment, congruent and proportionality, or 14th Amendment, deferring to Congress is, I think, not what we're supposed to do. So what, if we're not just deferring to Congress, is there anything you can point us to that would not allow it to extend forever? The intentional use of race, which you acknowledge in response to Justice Gorsuch.
Sure. Well, we maintain that there does not need to be a durational limit, but there is some guidance that this court could consider. So, for example, in Grutter, the court, Justice O'Connor, suggested that affirmative action did not need to endure beyond another 25 years. She forecast that another generation might need affirmative action, and ultimately this court thought otherwise in SFFA. So that sort of runway, that advance notice, that expression of an ability for Congress to intervene if it disagrees with the court or decides it wants to remedy on its own, that is the type of guidance I think this court should consider if it feels that it must pursue a durational limit on Section 2. And again, we don't believe that's necessary.
Justice Kennedy in 1994 in Johnson versus DeGrand, he said a couple things I just want to get your reaction to. He said the sorting of persons with an intent to divide by reason of race raises the most serious constitutional questions. And he added that explicit race-based districting embarks us on a most dangerous course. It is necessary to bear in mind that redistricting must comply with the overriding demands of the Equal Protection Clause. Do you take issue with what he said there?
No, what I think is missing from the understanding of Section 2 is the work that it has done to advance the goal of ridding our electoral process of race. It brings racial groups together, and as I mentioned earlier, many of the VRA opportunity districts ultimately convert to non-majority minority districts. Not all VRA opportunity districts are majority minority districts. And in fact, we see greater racial harmony and less racially polarized voting as a result of Section 2 districts. So Section 2 is addressing a pre-existing problem. It is not producing it. And in fact, it reduces it more broadly across society.
Thank you.
Justice Barrett?
I like the way she's
assumed without deciding, this is picking up on Justice Gorsuch's questions, that complying with Section 2 is a compelling interest for purposes of the 14th Amendment.
Correct.
And now this is kind of picking up on some of Justice Alito and Justice Thomas's questions earlier. How are we to think about that when we're thinking about the Robinson litigation? Because it was a preliminary injunction, and Louisiana, of course, argued there that no, it wasn't a violation of Section 2 to have those maps. So how do we judge the compelling interest in avoiding a violation of Section 2 if the state doesn't really think it violates Section 2 and it hasn't been finally adjudicated yet? How do we approach assuming that compliance with Section 2 is a compelling interest? How do we think about that in a context like Robinson?
So states can, for good reason, draw a map that addresses Section 2 prophylactically. Here we have a finding from a district court based on a robust evidentiary record that we were likely to succeed on our Section 2 claim. This is not the first case. There are many cases that have provided the basis for an opportunity map to be drawn just on a preliminary injunction motion. And again, that finding by the lower court was affirmed by 2 federal panels of the Fifth Circuit, and this court had an opportunity to revisit the Robinson litigation and did not.
But what if, district courts sometimes make errors of law, right? So what if the district court, I guess I'm trying to figure out how much weight then the district court's finding has in comprising that compelling interest in avoiding the Section 2 violation. Do you see what I mean? Like, what if the district court was just wrong, and what if the state thinks that the district court was wrong?
Well, the state has already conceded that it.
Okay, no.
The state already conceded that it should comply with the Robinson decision.
Right. I mean, it got complicated here because of all of the other litigation, but why don't you just strip out what happened and answer the question, like, at the time Robinson was decided. If Louisiana thought that the Robinson court was wrong, that the district court was wrong, but it wanted to avoid the court-imposed map, wanted the opportunity to draw its own map. Justice Kavanaugh's been asking you what role race can play without running afoul of the Equal Protection Clause. And the state would have to say at that point, well, we're weighting race heavily because we have a compelling interest in avoiding a Section 2 violation. And the state's position might be, we don't actually really think that we violated Section 2, but we have a litigation risk. We know that if we don't draw this other map, the court may impose one. On that understanding, on those facts, not concessions and whatever is made, is that then a legitimate, compelling state interest when there is the possibility and the state, in fact, thinks that the district court was wrong?
It is still a compelling governmental interest. The state can do what it did here, which is to appeal to the Fifth Circuit, and the Fifth Circuit considered the same evidence and unanimously found that the Robinson court was correct. Yet another Fifth Circuit panel also affirmed that decision.
Justice Jackson?
So in essence, are you saying in response to Justice Barrett that it's a compelling interest nonetheless because the state has an obligation under our Constitution and under Section 2 to provide an equally open electoral process?
Nice soft walk there.
I mean, I guess what I'm trying to really wrap my mind around is the different stages of this case and, like, the different questions at issue, because it's complicated. But I think the beginning of the whole thing is the requirement of equal protection in the Constitution and Congress's determination under Section 2 to make sure that that is being provided to minority groups in the electoral process by having a statute that requires states to provide equally open electoral processes. I mean, that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody, I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson Court is asked under Section 2, is this a situation in which that's not happening? And they go to trial and they bring in a lot of evidence and they do the thing, and the Robinson Court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson Court's decision is before us right now, because what I understood is that as a result of the Robinson Court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson Court has identified, and we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson Court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court. There's no record in the Callais case to support that.
Thank you.
Thank you, counsel. Mr. Aguinaga.
Thank you, Mr. Chief Justice, and may it please the Court. Race-based redistricting is fundamentally contrary to our Constitution. It requires striking enough members of the majority race to sufficiently diminish their voting strength, and it requires drawing in enough members of a minority race to sufficiently augment their voting strength. Embedded within these express targets are racial stereotypes that this Court has long criticized. They assume, for example, that a black voter, simply because he is black, must think like other black voters, share the same interests, and prefer the same political candidates. And this stereotyping system has no logical endpoint. We are 40 years removed from Jingles, and yet, according to my friends on the other side, nothing has changed in the voting and housing patterns in Louisiana that require race-based redistricting. These problems are part of why we never wanted to be here in the first place. They have placed states in impossible situations where the only sure demand is more racial discrimination for more decades. But I think if anything is clear in this court's dedication to eliminating all racial discrimination, it is that the Constitution does not
Hey guys, it's getting like super windy outside right now, so I am gonna go ahead and cut this here and we can come back at this tomorrow night. Because I'm afraid my internet's probably gonna go out soon. So, thank you everybody for coming by and we'll finish this tomorrow. Night everybody.